Hello and welcome to another episode of Calm Conflict, the Art of Resolution, where myself, Zakia, and David.
Hi Zakia, thank you very much. So I'm David Goldberg, I'm an accredited mediator, and I'm working with Zakia to hopefully bring some interesting podcasts.
We're going to be talking about how to resolve disputes early, efficiently, and with minimal stress. Every business owner knows that dealing with disputes takes a lot of time, energy, and it's a huge amount of stress trying to recover monies or deal with any type of dispute. So today, I'm going to be asking David how to actually resolve those disputes quickly and efficiently as possible. David, over to you.
Okay, a nice easy one to start. So obviously, if the relationship between the parties has already broken down, they need to see their own legal advice. Lawyers will hopefully speak to each other and apply some common sense because you're distant from it. I mean, this is, you do the same as me. We're both practicing lawyers as well. So it's more useful if you can distance yourself from something and have a conversation with the other side. If that doesn't work, you can try a without prejudice conversation with the other side. You can try sitting down in a room with the other side. But if tensions are against tense, it's not necessarily going to work. So I would again encourage getting into mediation sooner rather than later. Mediation doesn't have to be post-issue, it can be pre-issue, and often it can be a very useful way of resolving matters before the costs of issuing and the deadlines and time limits and everything else kick in. So that might be a very useful way of bringing things.
But with parties, sometimes they don't know the deep into the depths of a dispute until they get to that legal stage. I mean, is there any way they can try and this is mainly for businesses and parties, this episode. Is there any way they can sort of get to a mediator quicker than going to a solicitor and going through that process?
Yeah, you can approach a mediator direct. The only problem with doing that is a mediator can't. If you're coming to me direct as a party and you've not had experience of mediation before, it's going to be slightly tricky to put together a bundle of what's what. What I need to see as a mediator is the core stuff. So, it's relatively simple. If it's a contractual dispute, where's the contract? If it's a dispute in relation to invoices, where's the invoice? If it's a dispute in relation to quality of goods or defective services or something, there'll be some correspondence between the parties, emails, letters, something normally the parties, especially corporate clients, will have written to the other side themselves in advance to say, if we don't get this resolved, I'm instructing our lawyers. And that might well be the time to see whether you can find get into a mediation. The point is, as a mediator, I can step back, so I'm not involved. And the parties need someone impartial to sort of take a view on both sides, and steer, I think.
Yeah, because your role as a mediator is to be that neutral cog in the middle, making sure both parties aren't sort of, tearing each other's eyes out.
Absolutely.
Or pulling their hair out.
Absolutely.
That's your role. That's your role. But in terms of the parties going to a law firm, I mean, I always encourage from day one, if a matter is disputed, to say, look, let's not issue legal proceedings straight away. Let's see if we can deal with this by way of a settlement. And these are your options. One of those options being an independent mediator like yourself.
Yeah, no, absolutely. But obviously the first thing that will happen when someone comes to you as a lawyer and you'll say, come to me, let me sort the problem out, is you have the pre-action protocols to comply with. You'll do a letter of claim. And there'll be a response to that letter of claim. The letter of claim may not be spot on. It's not a pleading, but it sets out what the nuts and bolts of the claim are. The response to the letter of claim, again, sets out the nuts and bolts of it, and that may well be enough, to bring the parties to a mediation. You don't need to be, producing, reams of paperwork and hundreds of invoices and witness statements and everything else at an early stage. Depending upon the value of the dispute. It may well be something that needs to be honed in on, and a mediator can sit and say, well, actually, we need to narrow the issues early. What are the issues? You may have 3, the other side may agree with those 3, or may have 2 more of their own. So it's often useful if you do the pre-action protocol process, do the letter of claim, and then see where you are. And then as soon as you get bashed into a mediator will sort of grab it and shake it.
And that's one of what you just said about all the documentation, the witness statements, the evidence, collating all of that leading up to a trial. That's one of the most stressful parts of the process for parties. So avoid that stage.
Absolutely.
So have minimal stress. Try and deal with it before you even get to that bit. So even if court proceedings have been issued, you can ask the court to stay a claim, so put it on hold for a couple of months so that parties can negotiate a settlement or deal with a mediation with an independent mediator, so they don't have to go through the whole disclosure process in detail and in depth.
Yeah, absolutely. I mean, the point you were making was how do we do it with less stress? Less stress means you don't do the stressful side of things. So you don't have to prepare the witness statements. You haven't got to go through huge amounts of disclosure, discovery and everything else. And, at a mediation, if you've got letters of claim, a competent mediator will be able to pick out what the issues are. Okay, both sides will know what the issues are. Okay,
and then you're saying there are incompetent mediators out there.
Definitely not. But the obvious point is
an experienced
mediator will have a look at we'll see what's what. Okay, I will call both sides normally if I get a chance, and I almost certainly will every time. I'll speak to you if you're the solicitor for one side, and speak to the solicitor from the other a day or two beforehand, and just say, look, Zakia, what exactly do you want? Where do you want to be? It's 4 o'clock on next Thursday. Where do you want to be? And from the other side, and I can speak to you, and I can speak to your clients if we're doing a face-to-face Zoom, face-to-face, or if we're doing it over Zoom. I can do that evidence. I can probe the evidence of your client, and I can, so they get their say without having to go through the aggravation, the expense, the stress of preparing statements, going through disclosure, having to spend hours, sending it to IT people to, search for metadata and all whatever, everything else that might or not prove necessary for a mediation.
And when you speak to the parties on the phone prior to the mediation, do you ever get a feeling where some of them may not be serious about actually mediating or settling, not mediating, but settling a dispute?
Yeah.
Because sometimes you can't force parties to settle. Even on the day, mediation is not about forcing parties to settle. That's not my job. No. That's not your job. No. If they want to settle, they will settle. But do you ever get a feeling on the phone that someone's just playing a game?
No, so
or a party's just playing a game?
I've not had personally that experience where someone is just literally ticking a box to say I've done it. I did have one very, very early on, but that was a face-to-face, huge amounts of money, and there was an international arbitration going on, and I got the impression this was a box-ticking exercise. But generally speaking, when I'm speaking to you a couple of days before the mediation, I get the impression that your client's not really engaged, or they're not turning up or something, or you've got some, you're sort of saying to me, I'm not really got instructions on this. I will say to you, if we're going to make any progress, let's get on with it. But I will say very early on the day of the mediation, if we are wasting our time, I will tell you. If the other side is simply not engaging, or you're not engaging, I will tell you that if you're not going to engage, let's just call it a day. You're wasting everybody's time.
You say on the day, literally, I've experienced remediations.
Yeah.
Do you ever say, well, actually, if we're not going to settle this, and if people are not serious about this, or parties are not serious about this, then I'm walking out the door.
Yep.
Quite literally.
But not that early, because,
give them an opportunity.
I'll give the parties, I will give you a warning politely, and then a slightly less, perhaps, polite warning. Just say, look, we've been here before. We're going round in circles. You're coming up or coming down in increments of, £1. It's not going to work. I get, I understand where you're trying to go, but we're not going to get there. If you don't want to do it, let's just call it a day and crack on and litigate. And often just that realization, if clients hear me, you obviously have heard it before, but if a lay client hears, actually, the mediator's going to call this a day, when I leave your room or come off of your Zoom page, okay, and go into the other room, you're then going to be having a conversation with your client, say, this is it. We are.
Yeah, absolutely.
And if you don't do this, we are going to end up litigating because we've done the mediation, we've tried it, it hasn't worked. But also people are invested in time and money.
That's exactly what I was just about to say. It's the time and money they're spending on that day of mediation. So let's actually make sure we're fully engaged, fully participating and serious about getting to the bottom of it and resolving that dispute.
I think that's right. Most people are. I think most businesses want to resolve things. No businesses want this. Individuals don't want it. Lay clients don't want it. It's stress, it's aggravation, it's hassle. And the point you're making is, can we get rid of these quickly? Sooner you get into a mediation, the sooner you realise, both sides realise, and I think it's now, mediation is no longer the, the hands-on touchy-feely thing that it was sort of 15 years ago. I think now people understand, lawyers understand, corporate clients understand, most businesses understand there is a benefit in getting this thing done quickly, and getting it on, moving on, and resolving that in a commercial way.
And with little stress as possible,
as
like
little
I
stress
said.
as possible.
Amazing. Thank you so much,
Thank you very
David. And we will be bringing you another episode. So keep on watching, keep on listening. If anyone's got any questions, send David or myself a message, and we're happy to answer any questions around mediation. Thank you.
Thanks very much.
Thank you for listening. This podcast was brought to you by Right Here Creative, a video creative agency based in Oxfordshire. Check them out at rightherecreative.co.uk.